Yeah. Friday. Friday. Very well. Please don't move. B group matters. Don't move. Admission.
Yeah, adjournment. Page number 2, serial number 7 to 11. Serial number 7 to 11, 1 to 16, 17 to 23.
Serial number 21, my lord.
1 minute. Yes, sir.
Serial number 21, my lord. I request for 2 weeks time. I'm for
21.
petitioner.
A request made by the Lana Council applying for the petitioner list after 3 weeks. Yes.
What's up?
18. The request made by the Lana Council applying for the petitioner list after 3 weeks.
24 to 30, 31 to 38.
33. At the request made by the Lana Council applying for the respondent number 2 to 4, list after 3 weeks.
Number 39 and 40. All being spoken to, serial number 1. B. Ramesh.
I noticed. Thereafter, it was renumbered. It's there in para 5 actually. This code. Yes, sir. No. This code by order dated 12th September 2022. Dispose of the petitions. And as such passed the preliminary notification dated 21st July 1999 in respect of the schedule property. However, by oversight, it was stated as survey number 39 of which village? Of Avaragere village, Ramanagara Taluk and district. However, please stop. The said survey number was renumbered as survey number 93, 94 and survey number 95 and survey number 96. 6. Full stop. In that way of the matter, with these necessary corrections, the corrections, the order dated in order dated 12th September 2022. Scheduled property to be mentioned as a. The right for what? It is settled between the parties. The counsel applying for a petition has filed a memo dated 13/9/2022, seeking withdrawal of the petition as the parties to the petition have settled the matter. Accordingly, revision petition is dismissed as withdrawn. 2 weeks time is granted to come. Connection. Request. Here request. Here request. Comply with the office objection within 2 weeks. 2 weeks time is granted to comply with the office objections. 2 weeks time is granted. Notice only in preliminary, not in orders. You comply with the office objection, you move it. For preliminary, it is 1 week's time is granted to comply with the office objection. Same. 1 week's time is granted to comply with the office. Yes, sir. Connection, yes, sir. Original or certificate copy connection, yes. You seek dispensation. You seek dispensation. File an application. That's it. Yes, 1 week's time is granted to comply with the office objections. 2 days time is granted to comply with the office objections. 2 days time is granted to comply with the office objections. Yes. Yes, sir. Yes. 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 Correct. The already relinquished deed is also used. Whether the VDA is the competent authority to issue TDR or where is the, which is the planning authority? Yes, very good. Hey Krishna. Hey Krishna, accept notice for respondent. Next. Interim order, sir? Yes, very good. Hey Krishna, accept notice. Yes. Yes. Yes, 1982. Yes. Yes, sir. So, let the notice shall go. Let the notice should go. Learner AG accept notice for R1. Yes. So and so accept notice for respondent number 2 and 3. Issue emergent notice to 4 and 8. Let us read. 82 alla. It's 1986. 86. Let us read. And the parties to maintain status as on. Yes. 1 minute. What is annexure D, sir? What is that? Out of? What was the extent it was at 12? 12 guntas. How much you are entitled? How? So 12 guntas was acquired. How you are entitled for 10% development? Under which law? Under which law that you are entitled for the 100% development? Under which law that you are entitled for 100%? Under which law that you are entitled? You have to say that you have to make out a case for legal right. Yes, Mr. Vasant, what's the extent that you are entitled to under the 12 guntas of land is acquired. So according to them, I think remaining 2 guntas you are into. Under which law that you are entitled for 100%? There will be some law. No? Parabil. Told him. Shike Krishna accept notice for respondent. List. Third, the Lana Counsel appearing for the parties. It's the case of the petitioner that the respondent BDA had acquired 12 guntas and 2 acres, 2.09 guntas of land in survey number 77 and 78 of Alahalli village, Bangalore South Taluk, and has received the compensation in respect of the 10 guntas and 2 acres of land in survey number 77 and 78 respectively. It is the claim of the petitioner that the respondent BDA has not passed award with regard to 2 guntas and 9 guntas of land in survey number 77 and 78. And accordingly, the petitioner has made an application, has made a representation to the respondent on 16/2/2021 as per annexure D, and same has not been considered by the respondent authority. And then and as such, the petitioner has presented this petition. Having taken note of the contents in the annexure D, dated 16/2/2021, the respondent BDA, being an authority under Article 12 of the Constitution of India, is directed to consider the representation dated 16/2/2021 produced at annexure D in accordance with law and convey the same to the and result of the same be conveyed to the petitioner forthwith within 8 weeks from the receipt of this order. It is also made clear that this court has not expressed any opinion on the merits of the case. Yes. Yes, sir. Annexure. Annexure F. What is the claim, sir? Correct. That is 264. Yes. Consider, which is the one. Which is so and so accept notice for respondent 1 and 2. Sir, copy. Ardilana Council, Ardilana Council, directly. Ardilana Council applying for the parties. It is the case of the petitioner that the respondent authority has allotted site bearing number 264 under economically weaker section category, measuring to an extent of 6 into 9 meters, and thereafter, as per annexure A, and thereafter registered lease cum sale agreement was executed as per the dated 26th September 2008 as per annexure B to the Rectification. Pursuant to the same, the possession certificate dated 24 October 2008 was issued in favor of the petitioner. Consequently, the kata was registered in the name of the petitioner. However, the respondent authorities has cancelled the said site unilaterally, and being agreed by the same, the petition herein has made a representation, cancel the site as the subject site was situated in the Arkavati extension. Accordingly, the petition herein has made a representation dated 23/28/10/2021, produced at annexure F, and same has not been considered by the respondent authorities. Hence, this representation is filed. Having heard the Lana Council appeal for the parties, taking into account that the respondent authority has issued has allotted site number 264 in Arkavati layout as per allotment letter dated annexure A, consequently, possession certificate and kata was issued in favor of the petitioner. However, in view of the fact that the said subject site is situated in Arkavati layout, same was cancelled, and pursuant to the same, the petition herein has made a representation produced at annexure F, and same has not been considered. That way of the matter, and of the view that the respondent be directed to consider the same within 8 weeks from the receipt of this order, and the result of the same be made known to the petitioner. This also made clear that this court has not expressed any opinion, and the respondent BDA is independently considered the representation at annexure F to the rectification. Yes, sir. Yes, sir. Yes. Yes, sir. You file it, you file it. Yes. Yes, sir. Yes. Yes. Yes, sir. Yes. Annexure B. Yes.
the last one getting the 23.
Correct. 135 by 43. 135 4 elements. Yes. Correct. Yes, correct. 2 acres. Yes. Yes, sir.
Now, there was a exhibition decision for the pipeline as well as septic tank. And that exhibition was challenged by the brother's son. In the BP number 42,460 connected here.
Yes, sir.
Some report after hearing was demanded the matter for fresh consideration. Again, after consideration, my lord, our request was rejected again. Second
File. Annexure K. Correct.
So far as the 135 bar code, section 135 bar code, the extent of my brothers and carries some for the confirmation. Thereafter, award will be asked. After connection K1, K59.
59, sir.
When is the 61?
61, sir. Yes, sir.
Muhammad Bashir Azad.
Yes, 130.
Yes. In the award, Muhammad Bashir Azad, who is alleged to be the case from my brother, his name was shown to an extent of 15 days of time.
Correct. Yes, sir.
We are happy to use the. Now, thereafter, page number 3 number 3 is name also. Also.
Now the award is passed.
Now the award has been done. Now, so far as that 7 number sense of land, I have no limits because acquisition was confirmed in the name.
Yes.
Now, I am concerned with regard to 135 bar 53.
130.
Now, amended award came.
135.
135 bar 53.
53. That is 9 guntas of.
9 cents.
9 cents. 9 cents.
That continues to the last will be 9 cents. Muhammad
Correct.
Even under section 4 notification, I was not a part. 6 notification, I was not a part. And the award also came to be passed in the year 2022, my lord.
Yes, sir.
And the K4 and to election K4.
Correct.
K4 also. Even K4 also, I was not a part. That particular to the law, page number 77.
77.
77, paragraph number 2.
135 Bob.
Comes to my brother and the third party, Muhammad Razak. And nothing to do with this.
Now you are concerned with 135 bar 53.
Maintaining an extent of 9 cents. The 9 cents per lot, neither report the subject matter of clear petition, nor the subject matter of 4 or 6 notification.
Yes.
Now they want to, by way of amendment, they want to include this survey number.
Yes.
Provision of section 33 of the new act. 33 of the new act is spoken about and related to the compensation of the percentage value. Now they want to use the law.
That cannot be.
That cannot be. That is the second solution. There was no further notification. There was no section notification. So far as my land is concerned.
Yes.
Amendment is there.
Yes.
And my land is acquired under section 4.
Yes. Sorry. Issue notice. Cannot AG accept notice for respondent number 1 and 2. Issue emergent notice to respondent number 3. The award notice dated 8/8/2022 stayed till next set up. Just a minute. 8/8. Stay of disposition of the petitioner till next set of hearing. Maybe stay of disposition Stay of disposition in respect of the subject land till next set of hearing. Till next set of. It will be released. No, by afternoon it will be released. Which ones? Order sheet. Memo dated 21/9/2022 along with the document is accepted. Yes. What is the matter? Just a minute. But what your challenge here? One minute. Your challenge 1991 Annexure D and final notification relates to the. Yes, sir. Yes. Why you challenge on what ground? After issuing of no further action. Yes.
Land law already challenged the action. Back in the year 1991.
Just.
This declaration is based on the fact that he was not at all aware of that. Neither his mother nor him are aware of the actions.
Where is that? Where is that? Where? Page?
22 of the statement of operations.
That is 22613.
Yes. You not even seeing mother tongue. It was as far. In the rectification meeting.
Just 1 minute. It's the son of late Dasappan.
Yes. He's not signed. He says he is appointed under a partition in the year 2012. Whereas acquisition is of the year 1991. Challenged by the original as well.
1 minute. Limit notification 23/591. 23/6/1990.
We see paragraph 2, page 23 of the
Yes.
statement of operations. Petitioner claims to be one of the plants wherein survey number 20 parts.
Just a minute. 23/3 and 20/2
and 20
so 12 guntas and 14 guntas. Yes.
20/2 is 12 guntas.
According to them, premier notification 23/6. Yes.
Same acquisition. The date is
subsequently declaration of form.
It's the same notification. Previously mentioned there.
Yes, sir.
Page 2 of the declaration. Page 4 of the declaration.
Page 4 of 1 minute.
Paragraph 1.
Yes.
Petitioner's mother, Srimati Maraka, was the owner and possession of the agricultural land bearing 700. However, the land record. And thereafter,
What is the material to show that you are the owner of which survey number? 20/?
Equal to 12 plus is what is saying. Paragraph 2 of the regulation indicates that he acquired under a partition. And what is produced in support of it is not easy. Annexure C.
Sir, please read second line of your page 4. Agricultural land bearing survey number 20/0. Not typographical, but that will make a lot of difference. 20/2 is already challenged. Who is Maraka? Then you cannot. Very. Then after 10 years, your son will fight. No, after 10 years, your son will challenge it. No.
The very same petitioner has participated in the proceedings on behalf of the mother.
Right. 1/5. Of 1/5 of the statement or
My statement. Case called Sri Govindappa is present on behalf of the mother Maharashtra.
the Govindappa.
And in the next page, my lord, since he had
Dismissed cast. Sorry. This petition is filed. No. It's a clear separation. It's a clear separation. No, that cannot be done. I will pass it over. Yes, sir. Yes. Yes. After vacation, you have given already dates in some of the matters. Just 2 weeks. Just. Or very. On the next Monday. Monday, let us. So with an understanding that it will be taken. Tuesday we have civil matters. Request. Or else, okay. Tuesday. At the request made by the Lana Counsel appearing for the petitioner, distant Tuesday. Interim order granted earlier, extended till next date of year. Yes. What's the matter? After vacation. After vacation. So, list after 2 weeks. Yes, sir. Yes, sir. Just 1 minute. This meeting. What your challenge? Endorsement. Annexure E, that your challenge. Page 20. Endorsement. Yes, sir. No, not released. Who has to complete? Then, so how do you put a reply? I think similar. It was. I think they just 2-3 days back. Yes, Ajay Kumar. I think similar. The identical case, in which for release of the land is concerned. Huh? That is between yourself and the system. Why the yes? Who has to issue kata? Yes. After vacation. Because identical case had come up, I think.
The society has to say, there is right now calling out in the fields.
But so far as very same, I think this court has, I think similar order has been passed. Sir, copied it. Sir, copied. That is order dated 3rd November 2015. After vacation. No, nothing will happen 2 weeks. Let us wait. Some other matters. Take a chance. Next Monday, could it? Yes. List on 26th. Yes, sir. Yes, sir. After vacation. Just after vacation. Interim order granted earlier, extended till next time. Yes, sir. Yes, ma'am.
I am here for the respondent.
Yes, ma'am. Yes, sir. Annexure D, sir. B. Award notice. Correct. You have reduced.
Milord, there is some. Milord, there is some. I have one submission. There is some confusion about the
1 minute.
IF. Yes.
Yes. So there are 2 awards. Yes, yes, madam.
Milord, there is some confusion. Milord, my learned friend has filed one IA, and which is IA served upon us, shows that it is for amendment, and we have filed objection to that IA, where amendment has been sought for. But now, Milord, that what is before the court is IA for production of additional document. So which is served upon us, it is for amendment, to which we have filed objection. But
Only
now,
the question in this writ petition, whether you have an authority to issue 3 awards in respect of the very same subject matter. 33 lakhs 41. Whether it is.
Milord, there are not 3 awards have not been passed. There is only 1 award has been passed. And as per the award passed, that it was subject to,
2020
Milord.
matter.
Sorry, Milord.
It is a 2020 matter. You are supposed to get.
Milord, I am ready, but Milord, this IA, there is a confusion, Milord, because IA, what they have filed, it which is served upon us shows that they are seeking amendment, while as per COSDIT, it is IA for production of additional document.
Just to
So
tell me when was the award passed?
Milord, first, Milord, because in my IA they are seeking some amendment.
Just
for
1.
Other documents they are producing.
So when is the award passed by yourself?
Yes, Milord, award passed by
Just
SAA.
tell correct. We will leave it to them. When is the first award passed?
Milord, there is only, Milord,
Yes,
there is Milord, in my respectful submission.
Simultaneous. Yes, madam.
Milord, in my response submission, there is only 1 award passed.
When was the award passed?
Yes, Milord. Because we have not filed objection to main, we have filed objection to IA only, my lord.
Yes, you tell me,
Yeah.
madam, when as the.
But then in
first
that
award-
case, my lord, then once IA, there is a clarity on IA and amendment is if allowed, then we will file, my lord, statement of objection to main to amended petition, my lord. As of now,
Yes.
we have not filed objection at all, my lord. It is objection.
When is the
to-
first award passed?
Yes, my lord. I will give the.
30. That is award notice.
Yes, my lord, that is award notice. Award was passed only one award, my lord. And
When, madam?
yes, my lord.
So what was the determination as per award notice?
My lord, then in that case, my lord, lordship may allow me to file, my lord, statement of objection to main and we will ignore the IA, my lord. Then we will
According
file,
to when was the first award was passed? Yes.
my lord, I mean, my lord, I request your lordship to grant me some time, my lord, to file statement of objection, my lord. Where
It
I
is
will,
filed, madam. It is filed. At least
all
when
the-
was the first award is passed?
my lord, that what is filed is, my lord, objection to IA, my lord. We have not filed statement of objection to main petition, my lord.
Yes.
Because, my lord, there is IA for amendment. So we have filed objection to IA, my lord. And
Yes.
we will file a statement of objection once that decision on IA is taken, my lord. If it is allowed, then we will file objection to amended petition. But even otherwise, if your lordship, my lord, direct will file on next date, my lord, next week itself, my lord, will file statement of objection. Here,
Yes.
my lord, I will just give
You
one.
file it by next week, madam. Let us.
Yes, my lord. Next week I will file the statement of objection, my lord.
Sorry.
And we will,
Counsel.
my lord,
Counsel.
for the IA, my lord, we will ignore the IA. We will file objection to main, my lord.
For everything you file, whatever it is.
My lord, but that is, IA
Counsel
is not
appeal for
allowed yet,
parties,
my lord.
comma, this matter for further hearing, for further hearing next week, madam. 27th, madam, for further hearing.
My lord, I request 28, my lord. My lord, 27 I
28,
have
very-
obliged.
further hearing on 28. Let us.
Obliged.
Serial number 1800, serial number 19.
Yes, Santosh. We challenge the next year, 2002. Where is that? Where is that? Where is page 130. 1 minute. 130. Yes, sir. That is the 130. Your survey number is 116/3. Yes, sir.
Then proceed to the section A, number 130.
Yes.
Where the VA
16/3. ದಯವಿಟ್ಟು ಸರ್ಕಾರಕ್ಕೆ ಈ ಬಗ್ಗೆ ಪ್ರಸ್ತಾವನೆ ಕಳಿಸ್ತಾರೆ. 140. What happened before the government? ಸರ್ಕಾರಕ್ಕೆ ಪ್ರಸ್ತಾವನೆ ಕಳಿಸುತ್ತೆ ತೀರ್ಮಾನಿಸುತ್ತೆ. Yes. Yes. So pursuant to the annexure L and L1, they given those who are in the ಕೈಬಿಟ್ಟು ಸರ್ಕಾರಕ್ಕೆ ಈ ಬಗ್ಗೆ get instructions after vacation. After vacation indeed. Request made by the Leonard AGA list on. Yes.
Serial number 20.
Ayyappa? Yes.
Here an apartment on the street.
No.
Oh, I want an apartment.
Yes. Yes.
You have approached the lawsuit by saying that it's
What your challenge? What your challenge?
Since the notifications and notices. There is an interest.
Right.
Earlier they had a portion of the property. Initially the project was have 55%. Now it's reduced because the decision is that's reduced to 50. Even before we occupied the 30,000 square feet, and the compensation was given to the landlord as max. And after that, multiple acquisition of the now they have set an office at where around.
Yes. What is that? What is that your challenge here? Under this section 3 class 1 notifications owns of the KGB.
There are 5 permission.
Yes.
We have interested in the offices. Surprisingly, they have noticed the royal heritage club house. According to this clubhouse is the Partition of the property.
Who is the Anabodar or Patedar? Normally the notice will be issued.
According to them, they have verified an accident listing and then found that royal heritage clubhouse is the Partition. They also find that Mata page number 110.
Where is the preliminary notification? Just one minute. Where is the preliminary notification? Where is the preliminary notification? Which preliminary notification? Annexure? Annexure G. 180. 184. 184 or 90? 194. Just a minute. So chronologically we will. When was yes. 192 is 28 class 1. It is 4 to 21. That is the preliminary notification. 28-1. Relevant pages 190. The boss office. Yes.
In the city, they have found a small house.
You don't have. How did you get this actually? Royal Heritage Clubhouse. Where is the revenue? What is the revenue? R1. Just a minute. Partition. $17. Copy of the property tax and everything. Yes, Royal Heritage Clubhouse Office game.
page number 4 where I gave for vacating. Paragraph number 4. It's documented that Khata of the paid land, page number 2.
Page number 2 of? Yes. Vacating state.
Paragraph number 4.
Paragraph number. Vacating state. Para number?
Paragraph number 4.
Yes.
It's submitted that Khata of the paid land simply the name of Royal Heritage Clubhouse of this gym in the records of BDMP. Copies of the property tax paid receipts for the years of 18, 19, and 20 were produced. Your Lordship can please see page number 110. We have submitted the individual $200. Surprisingly, they are depending on the tax receipts for blocking the Khata when there are clear Khatas that extract your Lordship.
So what they got it from BBMP, and what is there in the document that they are reading? Yes, yes. It should be considered. Yes, ma'am.
This is my seven now. Multi undivided share,
Yes.
including the common area.
Very good.
All relatively.
Where is your Khata Act according to you? Whether the document number R1 and R2 is correct or not? According to you.
Could be wrong.
How?
Actually, here I have substituted.
Annexure. Annexure E. Annexure E. Yes. This is with regard to individual.
Once the process is completed, either a partial order,
I have not seen these. Right. Yes. They have no say in them. Yes. But you are not a Royal Heritage Clubhouse gym. You are not.
I don't have a gym. I don't have a clubhouse.
Then why do you worry? Then why do you worry?
They have said now they have sent an office. Saying that this notice as per section 28.
I shall vacate this. I shall vacate this stay, and it requires detailed consideration afterwards. That's it. Because the petition is a Royal Heritage Apartment Owners Association. How the association is having a right over the Royal Heritage Clubhouse? You are no way concerned with that.
They are not. They are acquiring the moment amenities of my apartment. They are acquiring the security cabinet.
Yes. The matter will be vacated. It will be heard the latest.
Actually, extend the claim your logic. If you are standard.
Because according to them, Royal Heritage Clubhouse, that is gym. That is what the tax is also paid. So nobody can pay tax.
I don't know. Your logic can finally consider other certificate for finding of the power. Here are the orders. The logic is also technically also ground to us.
Yes.
The moment is the logic against the state, it will be demolishing the property your logic.
Contention on the day on which the implement was done, it is contended that no notification has been issued, showing the name of individual apartment owners and no opportunity to file the objections. There is 4-1 notifications. 28-1. 190.
The violation of 28 and 20.
Let us.
I am the one.
28-4 is.
I have some case laws in your logic.
28-2 is also Royal Heritage Club. That is old PID number 50.
We have sent a representation to the, have to correct the name of the apartment.
Yes.
It is not the house, they are not the master. Even after getting this, even today they are issuing the notice to the clubhouse.
Yes. Good. This code. By it requires detailed consideration that because the petitioners anyway the petition name is not there in the Fatedar. How can it tell?
My property are acquiring. 28 says that the owner should be receiving
Yes.
an office. I am the owner of the property.
This code third. This code by order dated.
The owner of the property, it is not the clubhouse. Same way it is executed in favor of individual apartment owners, not in the clubhouse.
This code by order dated 20th-9-2021, comma, except comma, having taken note of the arguments advanced by the Lana Counsel appealing for the petitioner that the writ petition is filed by the Apartment Owners Association, comma, seeking stay of the improved notification produced at annexure F and R, whereby the respondent authorities propose to acquire 261.28 square meters of the property and the property. Today, the arguments was advanced by the Lana Counsel appealing for the parties pursuant to the application filed by the respondent seeking vacating the stay. Having taken note of the arguments advanced by the Lana Counsel appealing for the parties, comma, the prayer made in the writ petition is challenging the notification dated 4/2/21 under section 3 class 1 of the KAD Act within bracket annexure F and the notification issued under section 28 class 4 dated 31/3/2021. Consequently, seeking the relief of quashing the impugn notice dated 6/2/2021 produced at annexure G and subsequent notice at yes under section 28 class 2 and 28 class 6 of the Karnataka Industrial Area Development Act (ADI). Respondents have filed the statement of objection and also filed an application seeking vacating the interim order by stating that as per the property details in the BBMP, the Anubhavadar / Khatedar is the Royal Heritage Clubhouse Office Gym and not the petitioners herein. Accordingly, the petitioners herein have no locus standi to challenge the impugned notifications. So in this regard, the respondent authorities have also produced the tax paid receipts within bracket annexure R1 and R2, and taking into consideration the fact that the land belonging to the land said to have been belonging to the petitioner has been acquired for the purpose of the BMRCL, for the purpose of the BMRCL. I'm of the view that the interim order dated so and so be vacated, and in view of the contentions raised by the petition herein with regard to challenge the notification herein, the writ petition will be heard in due course. Yes.
If the clubhouse is taken, the compensation may not be given to clubhouse, which is not in the existing court.
Leave it to them. Leave it to them. Whom do leave it to them? Leave it to them. Whom they will give compensation.
According to the landlord, direct to the
Yes.
they have given the compensation.
Yes. Yes. Next minute. It's vacated, and accordingly, IA number 1021 is allowed. Yes, sir. One minute. Alternative line of. Have you approached them? Have you approached? Page 11. ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರ ಜಮೀನನ್ನು ವಾಪಸ್. So according to annexure B, say then that your land has not been acquired. Adhisoochane but acquired but not acquired but not issued notification. Yes, next. Yes.
They had promised to grant compensation. There is nothing proceeded.
Only thing is, if such been the case, they have to consider your representative time. That's all. Yes, sir. Annexure E notice. Annexure E is there. Page 15. Illegal utilization of our land, so and so, survey number so and so, to an extent of 7 guntas. Nachanapalli, Palya, Mysore Taluk. You consider and definitely. No court can say do illegally. No court can say that illegally you do it. Do it illegally.
Was passed for 1 year in the date of petition. Will they acquire or grant me equivalent? This is what the judgment is.
That they will consider. It's public money. Third, please don't. Heard the Lana Counsel appearing for the parties. It is the case of the petitioner Please run, please. This case of the petitioner is that the petitioner is the owner of the land bearing survey number 179 of Nachanahalli village, Mysore Taluk and district, measuring to an extent of 11 guntas, and the said land has been utilized by the respondent authorities for the purpose of formation of layout, and in this regard, the petitioner, the respondent authorities have issued the endorsement dated 4/1/2019 as per Annexure B to the Rectification. The grievance of the petitioner herein that though there is no acquisition proceedings have been initiated to acquire the 11 guntas of land in survey number 179 of Nachanahalli Palya village, Mysore Taluk. However, the respondent Muda has utilized the same for the purpose of layout, and accordingly the claim of the petitioner that the petitioner is entitled for alternative site, alternative land or / compensation under the 2000 so and so Act, 2013 the Fair Compensation so and so Act, 2013 Act. Hence, the petitioner herein has made a representation dated 3/1/2020, called upon the respondent authorities to allot the alternative land inter alia, seeking compensation under the 2000 Act. The said representation has not been considered by the authorities in that way of the matter. Having taken note of the arguments advanced by the counsel against the parties, the respondent number 3 herein is directed to consider the representation dated 3/1/2020 in accordance with law, since the land belonging to the petitioner has been utilized without there being an acquisition proceedings, which amounts to curtailment of the Article 300A of the Constitution of India, and in that way of the matter, respondent authority is directed to consider the same and outcome of the result of the same be made known to the petitioner within 8 weeks from the receipt of the order. ಮುಡಾದವ್ರಿಗಿಲ್ಲ, ಅದು ಏನು DC ಮಾತ್ರ. ಮುಡಾದವ್ರು ಏನಿದ್ರು ಹೋಗೋದಷ್ಟೇ, ಬರೀ ಫಂಕ್ಷನ್ ಅಟೆಂಡ್ ಮಾಡೋದಷ್ಟೇ ಅವರೆಲ್ಲ. ಐಮ್ ಅವೇರ್ ಅವ್ರು ಏನಿದ್ರು ಫಂಕ್ಷನ್ ಅಟೆಂಡ್ ಮಾಡ್ತಾ ಇರೋದಷ್ಟೇ ಮುಡಾದವರು. ಅವ್ರದ್ದೇನು ಕೆಲಸ ಇಲ್ಲ ದಸರಾದಲ್ಲಿ, ಬರೀ ಜಂಬೂ ಸವಾರಿ ನೋಡೋದಷ್ಟೇ. ನೆಕ್ಸ್ಟ್. ಎಸ್ 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 first the allotment letter dated 22/3. Yes. Annexure H. Yes.
Just from the 2-3, but it is not.
Which rule is sorry.
Not just like what is in the
Civic amenity. Yes, I can proceed. Yes. Rule 4. Correct. So, yes, disposal of sites reserved. Yes.
The sites reserved under subgroup 1 of Group G will be allotted to categories specified in terms and conditions and
Correct.
I say registration.
Yes.
Every institution self-authority of view. Right. Describe the table below. The product, the required, they have to register.
Yes.
State that site is started. Reject the letter of whom Lord I wanted to attack.
But the purpose is for the police station. Yes. Yes.
Which is here not the CS side, which we are using it from manual to here.
Yes. Yes. Please go to rule. Offer of civic community sites. Please read. Yes, that's why I start with notwithstanding anything in this. Please read 4 also. 4, please read rule 4. Sites reserved. Notwithstanding anything, these rules, the sites reserved under 3(1). That is what you are referred to. I think then it will come here. Up. One minute. To be civic community means. Police station. Yes.
This is
2000. After 4 years. Statement of objection. R1. R1 is I think government is also. Yes. 1 minute. Michael at center upon
they don't even the
1 minute.
on this is the Michael.
Yes. It is for police station. No, it is not a question of association. It's a public at large. Maybe true. Even any citizen makes an application is also such. Very well. Some association, very well. Yes. Anyway, it is already constructed. The lease come series agreement is 16 R7. 7 R6 is the government ordered it. So, ನಿಮ್ದೇ ಇಸ್ಕೊಂಡು ಮಾಡ್ಬಿಟ್ಟು. Yes. Yes, yes. Such a choice of the site or something is in the domain of the government. It is for civic community. It is for the police station. All of us are required. All of us are required the same. Not necessarily residents. Even all of us are required.
It is not. That's what our layout is fine. Step exists.
Yes.
Is implemented by the VA.
Yes, sir. Yes, sir.
Not with the funding of the prospective buyers. But we funded and with our funds, layout is all houses are constructed, but row houses are also constructed. Before not we made investment, we verified the layout plan. It shows that there are certain CSIs, which is reserved for the residents of the layout.
Yes.
CSIs can be used by this event. Ultimately, the object of not observing CSI is for the benefit of the members who have purchased the CSIs that have needs. But the layout is but a lot of the
Yes.
going to be well that is CSI which can be used by us. We invested and we have purchased the residing. Yes. This is not the when the layout is by the section 30 of the BD Act says that streets or location are not best in the country. They have to
Sir, irrespective of system, it is for a police station.
so as not police station is concerned, I also
It is for good for the society. Even if it for something else, I think even if there is any some irregularity or something else. Anyway, it is for good cause. It is for the good cause. Yes, yes. Annexure R3 of BDA. BDA. Area where it got behind that also vast my respect to is that area could have been utilized. Yes.
That is one. Second thing is not even if not the area of what powers to not CSI.
Anyway, it is for police stations, not much.
But the proposal was made for this side. Question came before the VA also. The question came before the VA also. But whether it can be allotted.
Yes. Annexure? Yes. That is. Anyway, the construction is already yet to be completed shortly. At this juncture, interfering with the same is not correct.
One page
46.
One page 46. The operating procedures page 47.
Yes.
Paragraph 2. SFHS ಬಡಾವಣೆ ನಿವೇಶನ ಸಂಖ್ಯೆ ಜಾಗವನ್ನು ನಿವೇಶನಾಗಿ ಮೈಕ್ರೋ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ದೀರ್ಘ ಮುಖ್ಯಸ್ಥೆಯನ್ನು ಈ ರಸ್ತೆಯ ಭಾಗವನ್ನು ಸಂಚಾರಿ ಪೊಲೀಸ್ ಠಾಣೆಗಳಿಗೆ ನಿವೇಶನ ಸೂಕ್ತವಲ್ಲವೆಂದು ಈಗಾಗಲೇ although PDA initially felt that it is not suitable, first they are able to not extend the window.
Yes. Yes.
The second question is but I am going to ask you on this. But the video says that it is not suitable for restriction of police station and the area is it is not
It is for the widening of the Bannerghatta.
Since we are using this for CS Act, this time mode. It is sufficient space not behind the existing micro police station. That area could have been utilized. By virtue of this, not no doubt, by virtue of this
Correct.
Disturbs not disturbing success, especially not
But the police people will be there in and around your houses. It's good, no? And your office bearers, no, their houses probably situated nearby. Their the police officers will be there. Slowly. Yes. Correct. Slowly. Yes, it will be considered. This is petition. For police stations is good for citizens. Yes. Yes. This petition is filed by precedence, by BTM layouts, BTM layout, within bracket, SFHS, SFHS close the bracket, Residents and Owners Welfare Association. Challenging the allotment letter dated 22/3/2018, issued by the respondent BDA. Proposed to construct MICO layout, MICO, MICO layout traffic police station in site number 26 capital bar A, 26 bar A of SFHS layout BTM second stage, Bengaluru. The grievance of the petitioner society that the BTM layout has been formed under self-finance housing scheme, and same is the said layout has been developed and implemented by the respondent BDA in the year 1982-83, and in the and in the said layout, comma, the BDA had undertaken to BDA has undertaken to allot the site bearing number 26/A, comma, initially shown as a road as per the approved layout plan. However, same has been allotted for the purpose of construction of Micro Layout Police Station. And therefore, the present petition is filed by the Petition Society, stating that the said allotment made in favor of construction of the police station is contrary to the allotment rules, relevant allotment rules of the BDA. Hence, this petition is filed. I heard Mr. So-and-so and a counsel appearing for the petitioner, and K. Krishna for the 3 and 4, and Leonard AG so-and-so for the. And a counsel appearing for the petitioner contended that, comma, the allotment of civic amenity site, particularly the site number 26/A, situated within the vicinity of the association, is contrary to the BDA within bracket allotment of civic community sites, close the bracket, rules 1989. He invited the attention of the court to the rule 4 of the aforementioned rules and 4 and 5 of the aforementioned rules, and argued that the allotment and the registration made in favor of the Micro Layout Police Station is contrary to the aforementioned rules, as the procedure contemplated under the rules has not been followed by the respondent BDA before issuing the allotment letter dated 22/3/2018. Accordingly, he sought for interference of this court. Per contrast, Sri K. Krishna and counsel appearing for the BDA reiterates the governments made in their statement of objection. Previous number. And a counsel appearing for the petitioner further contended that the BDA itself, in the note sheet, has arrived at a conclusion that the site number 26 is not feasible for the purpose of the construction of the police station. However, at the instance of the However, at the instance of the then minister, allotted the site number 26 for the purpose of construction of the Micro Layout traffic police station. Accordingly, sought for interference of this. Next. Per contra, Sri K. Krishna and counsel appearing for the respondent BDA reiterates the government made in the statement of objection and submitted that the BDA had allotted the site number 26 for the purpose of construction of Micro Layout traffic police station, pursuant to the letter addressed by the Police Commissioner Bangalore as per Annexure R1, and therefore contended that since the said site has been earmarked for the purpose of the civic community site. And as such, the agreement has been executed between the government represented by Police Commissioner of Bangalore City with the officials of the BDA, with the estate officer of the BDA as per Annexure R6 in the year 2000 site lease agreement, and accordingly we submitted that, though the said allotment has been made in the year 2018, the petition herein have challenged the impugned allotment letter in the year 2022, and therefore the petition deserves to be dismissed on the ground of delay and lapses. He further contended that, one BTM Residents Joint Action Committee has addressed letter to the respondent BDA for seeking allotment of the civic community site for the purpose of construction of micro layout traffic police station as per Annexure R2. And in that way of the matter, since the public interest is involved in constructing the police station, accordingly sought for the dismissal of the petition. So and another AGA, argued in line with the Lana Counsel applying for the BDA, and also invited the attention of the court to the photographs. In the photographs annexed to the statement of objections filed by the state, and submitted that pursuant to the allotment made by the BDA, the construction of the building is at the final stage, and therefore interference at this stage cannot be made, as the said allotment has been made for the purpose of public purpose. That in that way to matter, when an AGS is for dismissal of the petition. In the light of the submission made by the Lana Counsel applying for the parties, the petitioner association has challenged the allotment made in favor of the allotment made by the BDA for the purpose of construction of the site number 26 in BTM layout. And in this regard, have carefully considered the relevant provisions contained under the rules. Full stop. Rule 3 provides for offer of civic community sites for allotment, whereby the BDA has been empowered to allot the civic community sites available in any area, reserve such number of sites for the purpose of providing civic amenity site, and the rule 3(1) has to be read along with section 2BB of the Bangalore Development Authority Act 1976, which provides for the definition of civic community. Clause 5 of section 2 clause BB provides for provides for allotment of site for the purpose of construction of police station. Rule 4 of Rule 4 and Rule 5 provides for disposal of sites reserved for the purpose of a civic community site, and Rule 6 is provide for eligibility criteria. Taking into consideration the fact that the allotment of site has been made by the BDA for the purpose of construction of the micro layout police traffic police station at the site number 26, which is no doubt reserved for the civic community. I'm of the view that there is no illegality in making allotment for the said purpose. Though the Lana Council appeared for the petitioner, submitted with reference to the note sheet. However, on careful consideration of the big papers would indicate that the respondent BDA has executed the CA site lease agreement dated 5th August 2021 as per Annexure R6, and the possession certificate has been issued on 10/8/2021. And having taken note of the photographs and as well as the statement, as well as the government made in the statement of objections filed by the state, would indicate that substantial construction has been made by the respondent authorities for the purpose of construction of for the police station, micro layout police station. And in that way of the matter, I do not find any illegality or irregularity in allotting the site, which is exclusively earmarked for the purpose of civic community. Though the Lana Council appearing for the petitioner submitted that the said allotment has been made at the instance of the then minister. However, looking into the letter dated 25/11/2013 by the Police Commissioner Bangalore City to the respondent BDA, inter alia, one of the residents joint action committee of the local area also addressed letter to the respondent BDA dated 8/6/2016 for the purpose of construction of the police station. I do not find any merit in the argument advanced by the Lana Council appearing for the petitioner. It is also made clear that in view of the law declared by the 97, in view of the law declared by the apex court in the case of Ramanik law so and so, reported in year 1997, choice of the particular site or land for the purpose is within the domain of the respondent authorities. In that way of the matter, since the allotment of the site has been reserved and allotted in favor of the police station, I do not find any acceptable ground to interfere with the allotment letter issued by the respondent BDA. Accordingly, writ petition is dismissed. Ramanik law, year 1996. Yes. Yes. Should an endorsement? Is it a part of the petition? Annexure? Then you have to challenge, in the event if you are agreed, you have to challenge the annexure. You have to challenge the annexure D, sir. Yes. Yes. You have to challenge the annexure D, sir. Maybe it is already brought to your notice in 2012. No, it is there. It is your. Better you challenge. Unless you challenge, they cannot produce. No. So what is, no, it is not a certiorari proceeding, sir. It is only a mandamus. You challenge this order better. You have to challenge the annexure D, sir. If you are agreed by the annexure D, that you have to challenge. No, you can challenge. Because already they have made the order. Yes. Even subsequent, subsequent to annexure 12, you can, or else you can make one more representation. That's all. No. Cannot be called on. You can make one more representation with the relevant documents. Sir, by annexure D already. Yes, sir, but annexure D, all the things have been considered. Yes. Sir, if at all, if you are accrued, you can challenge annexure D. First, alternatively, you make one more representation. That's all. That's what I'm saying. You wanted to give relief to his client. That's the only way out. So therefore, what I'm saying, already it is rejected. Sir, already it is rejected. Unless you challenge it, it cannot be considered. (28/5/20) 2012. Sir, it is a writ of mandamus. There will be a demand and refusal. There will be a demand and refusal. Yes. Yes, sir. I think they have given a 21/10/2021 one representation. Annexure C. You consider as anyway, it's already you rejected. Monday is a Maru police station. Anyway, you consider it. Anyway, so annexure D has been passed. Of course, you consider annexure C dated 21/10/22. Yes, that's all. Third. It will be considered, sir. Anyway, it is rejected. Already it is rejected. Yes, consider it. Yes. Ardilana counsel appealing for the parties. It is the case of the petitioners that petitioner is a senior citizen and has made an application for seeking allotment of site And despite 6 attempts for securing the plot site has been made by the petitioner by register herself for the allotment of the site under registration number 98045, however, the same has not been considered by the respondent BDA, and accordingly, the petitioner herein has made a representation dated 21/10/2021 within bracket annexure C to the petition, seeking consideration of the grievance of the petitioner. Hence, since the same has not been considered, the present petition is filed. Shri Gunjalana Counsel appearing for the petition contended that, though the 6 attempts have been made by the petitioner herein, however, the petitioner herein is not able to get a site, and therefore has approached the respondent authorities for seeking redressal of her grievance. In this connection, Mr. So-and-so Ajay Kumar and a counsel appearing for the BDA invited the attention of the court to Annexure D dated 30th August 2012 and submitted that, the number of attempts made by the petitioner is only 4 in number. 4 plus is 4 plus 1, and therefore the consideration will be made as and when the eligibility criteria of the petitioner will be considered in accordance with the provisions contained under the BDA Act. In the light of the submission made by the Lana Counsel appearing for the parties, even after considering Annexure D, whereby the BDA has informed the petitioner herein in the year 2012 that the petitioner herein has made 4 plus 1 attempts to secure the allotment of site in the BDA, in the respondent BDA. However, there is no impediment for the petitioner. However, there is no impediment for the respondent BDA to consider the Annexure C dated 21/10/2021 at earliest within an outer limit of 8 weeks from the receipt of this order, and convey the same. Yes, sir. And convey the outcome of the same to the petitioner. Yes, it is also made clear that this court has not expressed any opinion on the merits. Yes. Yes. 2022, sir. Up to 3-4 years we have to be. No. Except AGA seeks 4 weeks time to file objection. Just after 4 weeks. Let us wait. Date bidi amele it's very difficult. Nothing else. 68 indra andre otogbidute petition beda. That cannot be. Let us wait. Let they will file an objection. Yes, ma'am. Yes, ma'am. Kiran C. Which is that, madam? Fine. Which representation has to be considered? But Annexure J 11/2/2020. Now they are saying that Padari Niveshana Moola Kadattadalli Annexure K is the K note. Thereafter they have filed H and K will be considered. Sorry, third the Lana Counsel appearing for the parties, this one is the case of the petitioner that the site number 1145 measuring 30 into 40 B. In survey number 10 and 11 of Tavarekere village, first stage BTM layout, first phase was allotted to the petitioner on 23/8/1990, and thereafter the marginal site was also allotted to you, and as there is as per annexure B, as per annexure D, and the marginal site was also marginal land was also allotted in favor of the petitioner. The grievance of the petitioner in this, that the petitioner has produced all the relevant records relating to the subject site to the respondent BDA for the purpose of registration has to be made for the purpose of registration of the sale deed with correction of the correction of the schedule to the said site number 1145 as per annexure H and K, and same has not been considered by the respondent authorities. Hence, this petition is filed. Third, Radha Madam, so and so for the petitioner, and your good name, Madam? No, you respondent.
Kiran Civic. Your name, ma'am?
So and so. Madam so and Sahana for the respondent on behalf of Kiran Civic. Having taken note of the grounds urged in the petition and the arguments advanced by the counsel appealing for the petitioner, it is not in dispute that the site number 1145 has been allotted at Tavarekere village, first stage BTM layout, first phase by the respondent BDA as per allotment letter dated the letter dated 23/8/1990, and possession certificate has been issued on 9/10/1996. Thereafter, it appears that the petitioner herein has purchased the marginal land by making necessary payment to the respondent BDA. However, the registration and the rectification of the schedule has not been made till date, and accordingly, the petitioner has made a representation dated 24/1/2020 and 12/2/2020, produced at annexure H and K respectively, and same has not been considered. That way of the matter, taking into consideration the factual aspects on record, respondent authorities are directed to consider the representation at H and K the earliest within outer limit of 8 weeks from the receipt of this order. Yes. 8 weeks from the receipt of this order. Yes. Yes. File objection. File objection. The counsel appealing for AGA seeks 4 weeks time to file objections. Yes. Yes. Who has to consider? Formation of the road. Yes. Connection 38. 1 minute. Yes, sir. In the light of this proceedings dated 16/1/2012, let they will consider.
Now I am given.
Yes. Yes. Third, the Lana Counsel appearing for the parties. It is a case of the petitioners that the land bearing survey number 73 and 74 of Nagadevanhalli village of Kengeri, Hobali, Bangalore South Taluk, whereby the respondent authorities have utilized the portion of the land for the purpose of formation of 80 feet road. And in this regard, without acquisition proceedings, without acquired for utilization so and so. However, the compensation has not been paid to the petitioner, and therefore the petitioner herein has approached the respondent BDA by representation dated 24/1/2022 within bracket annexure E, requested the respondent BDA to allot the alternative site in lieu of acquiring the survey number 73 and 74, which are developed land. Full stop. In this connection, full stop. She Karumbayal and a counsel appearing for the petitioner invited the attention of the court to the annexure J to the petition and submitted that in terms of the resolution dated 16/1/2012, whereby the respondent BDA is empowered to allot the developed area in favor of the land users, and therefore there is no impediment for the respondent BDA to consider the representation in the light of the said resolution dated 16/1/2012. Within bracket annexure G. Mr. Srovansol and a counsel appearing for the BDA, opposed the petition. In the light of the submission made by the counsel appearing for the parties, it is not in dispute that the portion of the land, as alleged in the petition, has been utilized for the purpose of the construction for the formation of Jnanabharati layout. The Jnanabharati layout, as per annexure D to the petition, and also I have considered the resolution dated 16/1/2012 as per annexure J, taking into consideration that the grievance of the petitioner that the petitioners have not been compensated till date, there is no impediment for the respondent BDA to consider the annexure E dated 24/1/2022 in the light of the resolution dated 16/1/2012 produced at annexure J, and outcome of the same be made known to the petitioner within 8 weeks from the receipt of. Yes, sir. Seeking under the present act, that they will file objection better. Kiran CV, yes, madam. I know, madam, you are appearing. You want to file objection or not? That I have to say you have to file. Not correct. You should be very vigilant. In fact, I have to say you have to file objection. File madly. You have to ask for, otherwise I cannot. Otherwise I will dispose of. But ask for, I think who is Kiran CV is not appearing. Yes, Krishna sir, please intimate them. None of the petitions is appearing. I've noticed actually. It is last turn. In the event if it does not, make any submissions, I will direct the BDA to change the counsel. Either they should be in the court hall, or else there will be some assistance. Otherwise, it's not correct. BDA land is very important nowadays, financially and as well as. Then a counsel appearing for the respondent seeks time to file a statement of objection. Just after 2 weeks. Let us. Our time next week anta kelala. ಟೈಮೇ ಕೇಳಿಲ್ಲ, ನಾನೇ ಕೊಡ್ತಾ ಇರೋದು. ಹೇಳಿಲ್ಲ 2 weeks ಲೇಟೆಸ್ಟ್ 2022 ಅಲ್ಲ. ಕಿರಣ್ ಬಿ ರಾನ್, ಎಸ್. Yes.
Petitioner's marriage is situated within the buffer zone.
Just a minute. Just 1 minute. What is the prayer? Declare that the land so and so. You file objection. File objection.
Finally, unable to utilize the land.
Finally, number 1 is finally number 2. And a counsel appearing for the respondent seeks 3 weeks. Let us visit. 3 weeks time to file objection. Better. The declaration is sought. That they will file. Yes, Jagdish. Who appear for the industrial area development? ಇಲ್ಲ. Consider representation. May be disposed of. Okay. Please go to Annexure G for a minute. Declaration survey number so and so as industrial area. Paragraph, sir? Told him. Yes, Hardilana counsel appearing for the parties. Short question involved in this petition is with regard to the consideration of the representation dated 27/4/2022 produced at Annexure G to the writ petition. It is the grievance of the petitioner that the respondent 2 and 3 have not taken the appropriate steps pursuant to the representation dated 27/4/2022. And in this regard, the Lana counsel appearing for the petitioner invited the attention of the court to the paragraph 4 of the said representation dated 27/4/22, wherein, wherein the KDB had has undertaken to notify certain lands in the vicinity of Adi Narayana, Sahalli, Panagatta and Nagadevanhalli village. And in that way of the matter, considering the apprehension expressed by the petitioner's hearing, respondent number 2 and 3 is directed to consider the representation dated 27/4/2022 within 8 weeks from the receipt of this order and convey the result of the same to the petitioner.
3-1 is done. Now, they do 28. Implemented. All that I request is, landowner goes the right way, if they go, they consent for
Let us will see. Within 4 weeks. Within 4 weeks from today. Yes. Yes, sir. Respondent to issue allotment letters LDD as per. Yes. Yes. Now what was allotted to you was cancelled and now someone is. I know. No, that is Annexure J2 tane. Annexure J1 and J2 tane. Instead of that, in the very same prescribed, where is that, sir? 48. 1 minute. 48 is the OS order. Contempt ಆಗ್ಬೇಕಷ್ಟೇ. H2, page 73, H1. Anyway, you withdraw the RFA, consider. In a regular format. Do one thing, sir. Do one thing. Let they will consider it. In addition to that, in view of the judgment and decree in so and so, you make in a particular format. Section 38 E D of that they will consider. In addition to that, you make you approach them under section 38D, because that is already the judgment and decree in 7568. Yes. Because there is already a provision, so it's better to make a application as per 38D, correct? Just for a minute, please read it, 38D. Please read 38D for a minute. Reserved for past ones. Anyway, the conditions are there. Made one more representation in accordance with 38D. I know. Let us use 38D. Just let them. Yes. Heard the Lana Counsel. Heard the Lana Counsel applying for the parties. The short, please sit down. Please sit down. The short question involved in this petition is with regard to direct the respondent BDA to consider the annexure H1, annexure H1 dated 24/5/2022 and H2 dated 24/5 H1 and 10/6/2022 annexure J1 to the writ petition. It is the case of the petitioners, the petitioner and petitioner is in unauthorized occupation of the property bearing number 1089/C, formed in survey number 95, 96, 121 and 122 of Hosakerehalli, Banashankari, third stage, situated at the 9th Main, Kalidasa Nagar, Bangalore, and pursuant to the scheme framed by the respondent authorities, the petitioner has made an application to the respondent BDA to regularize the scheduled property as per Annexure A to the petition. It is also noted in the, it is also stated in the petition that the petition herein has filed OS number 7576 of 2007 before the City Civil Court, Bengaluru, seeking relief of in OS number 772, seeking relief of permanent injunction and mandatory injunction, now coupled with the declaratory relief. And the said suit came to be decreed on 5th January 2016, whereby the trial court directed the respondent BDA to consider the application dated 12/5/2003 for regulation of the site in question in favor of the petitioner. But your aunt is the petitioner, plaintiff actually, in favor of the aunt of the plaintiff, dash B Sumitra, in OS number 7576 of 2007. The grievance of the petitioner that though they said or though the representation has made to the petition to the respondent authorities, and also the direction has been issued by the trial court. However, the subject site has not been regularized in favor of the petitioner. Hence, the present writ petition is filed. Secante Gowda, Lana counsel appearing for the petitioner, invited the attention of the court to the operative portion of the judgment and decree in OS number 7576 of 2007 by the on the file of the City Civil and Sessions Court, Bengaluru, and submitted that despite the direction has been issued by the trial court, and that apart, the representation produced at annexure J1 and H1 has been given to the petitioner, however, same has not been considered. Per contrast, Sri K. Krishna Lana counsel appearing for the BDA, invited bringing to the notice of the court the provision, bringing to notice of the court section 338D of the Bangalore Development Authority Act 1976, and submitted that the petitioner has to make an application under the said provision, and if such being the case, the same will be considered by the authorities in accordance with law. The right of the submission made by the Lana counsel appearing for the parties, and taking into account the trial court has already directed the respondent BDA to consider the case of the petition for regularization of the subject site in question, and also the representation made by the petitioner's hearing, I'm of the view that taking into consideration the provisions contained under section 38D of the Act, Bangalore Act, hearing of Act, petition hearing is permitted to make one more application in terms of the section 38D of the Act to the petition to the respondent hearing within 2 weeks from today. If such an application is made by the petition hearing, same shall be considered by the respondent BDA 8 weeks thereafter, and outcome of the same be made known to the petitioner. This observation, the petition is dismissed. Yes, sir. 38. 3 months, sir. Within 3 months, 8 weeks, but within 3 months from the receipt of the said application that may be made by the petition. Yes. Anyway, not enter the petition. Commissioner Radu, or ಕಾನೂನು ಅಧಿಕಾರಿ ಇಲ್ಲ, ಅವರು ಅವಾಗಿದ್ದವರು, ಇನ್ನೊಮ್ಮೆ ಮೇಲೆ ಬಂದ್ಬಿಡ್ತಾರೆ, ಬೇರೆ ಇನ್ನೊಬ್ರು ಬರ್ತಾರೆ ಕಾನೂನು ಅಧಿಕಾರಿ. Anyway, it will be considered. Very well. Yes.
Dhananjaya VS.
Similar petitions we have disposed. Sorry, short question involved in this petition, that the respondent authorities have to consider the representation made by the petitioner's hearing as per annexure B and E dated 12/9/2018 and 31/5/2019 respectively, without expressing first of view of the having taken note of the amendments made in the said representation. I have to view that the respondent authorities shall consider the same in accordance with law within outer limit of 8 weeks from the receipt of this order. So accordingly, the petition is disposed of. Yes. 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 So after preliminary notification, no further. Yes, madam, what do you say? No, you have issued, no. You have issued notification as per annexure F. And thereafter, any progress has been made. For which layout? Let us visit. Get instructions. No one. Nana counsel applying for the respondent 3 and 4, 6, 3 weeks time to file objection. Let us visit. Yes. Please. Challenge even endorsement also. What are those endorsements?
Rejected our claim for.
Anyway, that you have challenged this also. But however, you have challenged those word endorsements. No, are hereby passed. Yes, sir. Oh, as per annexure, as per order dated 30th March. Yes. Who has to consider deputy commissioner? Deputy commissioner or SLU? Having heard another counsel appealing for the parties, is stated in the petition that this court by order dated 30th March 2021 in WP number 32156 of 2015 within bracket annexure A, passed the impugned endorsement therein, and as such remitted the matter to the respondent number 3 to determine the compensation in accordance with law. Pursuant to the same, the petition herein has have approached the respondent number 3 by way of representation dated 8/2/2022 annexure E to the writ petition, and same has not been considered. Annexure? That's why. And thereafter, of course. Pursuant to the order passed by this court in the aforementioned writ petition, award came to be passed by the respondent number 3 as per annexure B. And subsequently, the petitions herein have requested the respondent number 3 to ಮುಖ್ಯಮಂತ್ರಿಗಳ ಮನೆ ಮುಂದೆ ಎಲ್ಲ ಹೋಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು, ಅದನ್ನೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. How can I give direction? Don't go to CM. How can I consider it? That's all. Then you have to make one more representation. If you say that ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಗಮನಕ್ಕೆ ತಂದು ಮನೆಯ ಮುಂದೆ ಉಗ್ರ ಪ್ರತಿಭಟನೆ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ, I don't want to say that consider it. Then court is giving an order, go there in front of the CM's house. However, the first up in this regard, the petition herein has made a representation dated 2/8/2022 and same has not been considered. However, after considering the contents of the annexure D, I am of the view that in view of the contents in the annexure D, I am of the view that the petitioner here is petitioner be permitted to make one more representation for seeking redressal of grievance in accordance with law within 2 weeks from today, and in such an event if the said representation has been made, the respondent authority shall consider the same within 8 weeks thereafter. Otherwise, it's not correct. Otherwise, then you will go there and you file contempt thereafter. ಉಗ್ರ ಪ್ರತಿಭಟನೆ ಅಂತ not correct. ಅದಿಲ್ಲ ಅಂದಿದ್ರೆ ಮಾಡ್ತಿದ್ದೆ. That's why we have to look into the representation. Nothing else. Within 8 weeks. Yes. Passed over.
So, madam,
Third. Heard in part. When do you want? From the after further reading. Day after tomorrow. Day after tomorrow further reading ಅಂತ ಹಾಕಿ. File ಕಳ್ಸಿ.
number 37.
Yes, sir. Hi, sir. Correct. Cutting ಬೇರೆ matters takes long. ಬೇಡ ಬೇಡ. Monday ಅಥವಾ Wednesday ತಗೊಂಡು. Wednesday. Tuesday also it may be taken. 26th ಬೇಡ. 27, 28 ಏನಿದೆ. ಬೇರೆ ಬೇಡ. ಹೌದಾ? We have certain batch matters. 27th, better 28.
Or 29.
29th, let us use. List on 29. Sorry, Lana Senior Counsel, Srivastava argued on behalf of the petitioner. No representation on behalf of the respondent 2, 3, and 4. In order to provide a last opportunity to the respondent, this turns out. Interim order granted earlier extended until further orders. Huh? Oh, very good. So without reading the papers. 2:30, let us will see. ಇವಾಗ ಒಂದು half an hour ಇದೆ.
Court officer, madam. Court officer. Hello. Hello, court officer.
Hello, court officer. ಇದು ಆಡಿಬಲ್ ಇದೆಯಾ ವಾಯ್ಸ್?
ಇದೆ ಸರ್, ಇದೆ. ಧಾರವಾಡ ಬೆಂಚಾ?
ಹೌದು ಹೌದು.
ಇದೆ ಸರ್, ಇದೆ.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಏನಾಯ್ತು? ಕೋರ್ಟ್ ಆಫೀಸರ್
After 2 weeks.
ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಥ್ಯಾಂಕ್ ಯು.
ಬರ್ತಿದಾರಾ ಸರ್?
Only 10:30. Ten 10:30. Tomorrow it will. Yes.
Matter pertains to Dharwad bench. Serial number 1.
Your Lordship's kind permission, may I make one submission?
Yes, sir.
I appear for the appellant in this matter, my lord.
Yes, sir.
Note the appellant has engaged the services of senior counsel. Has also
Let will argue.
please. Senior will argue, ma'am. If your Lordships permit, your Lordships kindly permit.
Very well.
Please, highly obliged.
Yes,
My
yes.
lords,
Yes.
I am appearing for appellant along with Mr. Maliwal.
Yes.
Lords, the plaintiffs are the respondents here.
Yes, sir.
The defendant number 2 has filed this appeal.
Yes, sir.
Lords, the case of the plaintiffs is that they are the legal heirs of one Shivrudraya.
Yes, sir.
And according to the plaintiffs, Shivrudraya and his cousin brothers, namely Chennaya and Gurlingaya,
Yes,
were
sir.
the co-partners of the joint family.
Yes, sir.
And one Mr. Shankaraya, though happens to be the relative of this family, he
Yes,
was
sir.
not a co-partner and he was not having a legal share in the properties.
Yes, sir.
But however, by virtue of an alleged partition registered dated 15/7/1940, my lords,
Yes, sir.
they have entered into a partition and they have divided the joint family properties.
Yes, sir.
Whereas according to the plaintiffs, my lords, the suit schedule A, B, and C properties are kept for the usage of one mutt by name Gangadhar Mutt.
Yes, sir.
And suit schedule A properties are landed properties, my lords. According to the plaintiff, these properties are kept for the usage of the mutt,
Yes, sir.
and the usufructs thereof shall have to be used for the development of the mutt. And
Yes, sir.
in that view of matter, according to the plaintiffs, there is an agreement in the partition deed dated 15/7/1940.
Yes,
And
sir.
accordingly, these properties were standing in the name of one Channabasaya, my lords.
Yes, sir.
This Channabasaya is stated to be the Mathadikari of Gangadhar Mutt.
Yes, sir.
And the properties are mutated in the name of this Channabasaya. And
Yes,
right
sir.
from the year 1940, my lords, till the date
Yes.
of death of this Channabasaya, that is on
Yes.
6/6/1991,
Yes.
these properties are standing in the name of Channabasaya.
Yes.
And this Channabasaya and the present defendant number 1, my lords, who happens to be the son of Channabasaya,
Yes,
both
sir.
of them together have executed a sale deed in my favor
Yes.
in respect of suit schedule A1 property, my lords. That is
Yes.
survey number 651/1.
651/1. Yes.
my lord. And thereafter, by virtue of the sale deed, I have come in possession and enjoyment of this property, my lords.
Yes.
So far as I am concerned, I am only concerned with this property. My lords, according to the plaintiffs, this Channabasaya Swami, during the year 1994,
Yes.
he attempted to create encumbrance over the suit properties
Yes.
and tried to alienate. That is the case made out by, my lord, the plaintiffs.
Yes.
And the plaintiff number 1 is stated to have applied to the Tahsildar to enter his name in the record of rights.
Correct.
And the revenue proceedings continued till 1993.
Yes.
My lords, meanwhile, in the year 1991, the Channabasaya Swami Mathadikari has expired.
Yes.
Thereafter, my lords, in the year 1993, the present suit came to be filed.
Yes.
My lords, here, this is the sum and substance of the case made out by the plaintiffs here.
Correct.
My lords, I being a purchaser, I have denied the plaintiff averments. And according to me, I am the bona fide purchaser. I do not have any knowledge of the internal arrangement made by the plaintiff's father and Channabasaya Swami and other members of the family.
Yes, sir.
My lords, here, the learned trial court and first appellate court have held that I have failed to prove that I am a bona fide purchaser. That was my contention before the courts below, my lords.
So you have purchased the property from whom?
From Channabasaya Swami, that is.
How did you get the property actually?
My lords, according to the plaintiffs, he got the property by virtue of a registered partition of 1940.
According to you?
My lords, according to me,
Is
Channabasaya,
he your vendor?
yes, my lords.
Yes. How did he get the property?
He represented to me, my lords, that he is the absolute owner, and by saying so, he himself and his son, the defendant number one, both have executed the sale deeds.
On what basis? On what basis?
My lords, I am guided by the revenue entries, and for 5 decades prior to my sale deed, my lords, for 5 decades the entries are standing in the name of Channabasava Swami as an absolute owner, my lords. There is no indication in the.
But the revenue records will not confer any title.
True, my lords, but I am guided by the revenue records because usually what happens, my lords, a bona fide purchaser will obtain the encumbrance certificate for the period of about 12 years,
Yes.
at the maximum 30 years, my lords. Here what has happened, more than 5 decades, the name of Channabasava Swami has entered and there is no mention in the column number 11, my lords, as regards the restriction imposed on this Channabasava Swami. This is number 1, my lord.
Yes, sir.
Well, also the courts below have taken up the, we have formed an opinion only on the contention taken by me in para number 6 of my written statement, my lords, wherein
Yes.
Lordship may kindly see from the paper
Yes.
book.
Paper book again.
WS of defendant 2, my lords.
Paper book, yes, just a minute.
Please,
Page, sir?
page 13, my lords.
31, yes, sir.
1-3, my lords.
1-3,
Page number,
yes.
in page number 13.
1-3, yes.
Yes, ma'am.
Para?
Para 6, my lords.
6, yes, sir.
The entire contents of the para 3, except that on 15/7/1940, the above said proportioners got effected a family partition of family properties are false and made out, concocted by the plaintiffs for the suitability of the case. Therefore, this defendant denies the entire contents of the para 3, except that there was a family partition in the year 1940. Therefore, the same may be put to the strict proof. My lords, what has happened here? This statement of mine that in the year 1940 there was a partition. This has been taken by the courts below that an admission on my part that I was in the knowledge of this partition deed. Because, my lords, I have admitted this partition because
Yes.
later on it has come to my knowledge that there is a registered partition deed. So fairly I
Yes.
have admitted. It does not mean that, my lords, at the time of purchase of the property in question, I was having the knowledge about this partition of the year 1940. And
Yes.
moreover, there is no, my lord, there is no mention about this partition deed. There is no mutation entry regarding that the name of Channabasava Swami is entered in the record of rights by virtue of the partition deed.
Yes.
Nowhere we can find that such an entry is there or any mutation is there. There is no such mutation and no such records, my lords, has been
Yes.
placed on record by the plaintiffs. So, my lords, when I have taken up the contention that I am the bona fide purchaser, it is for the
Yes.
plaintiffs also to show by placing some material on record that it was within my knowledge that the 1940 partition was known to me and knowingly well about the restrictions imposed in the partition deed. I have proceeded to purchase this property. This is number
Yes.
1. So far as this has been taken as admission on my part, my lords, the law is well settled on this point. Admission must be clear and specific.
Yes.
Merely because, my lords, I have admitted that there was a partition, it does not mean that having the knowledge about this partition deed, I have proceeded to purchase this property.
Yes.
So such an admission is nowhere in my written statement, my lords. So the courts below have failed to understand the pleadings of mine, and
Yes.
straightway they have proceeded to hold that only because of my contention of having admitted the partition of the year 1940.
Yes.
As per para number 6, my lords, they have taken that having the knowledge about the partition deed, I have proceeded to purchase the property and
Yes.
am not a bona fide purchaser. Except this reasoning, my lords, there is no other reasoning to deny my contention that I am a bona fide purchaser.
Yes.
My lords, apart from this, my lords, what happens, my lords, I being a bona fide, I am a member of public. and I do not have any internal knowledge of any internal arrangements of the
Correct,
family
correct.
of the plaintiff, my lord. And somewhere there should be a mention in the record of rights. And the record of rights reveal that, my lords, from the year 1940 till the year 1990, the day when I purchased this property for a period of 5 decades,
Yes.
it is showing that the Channabasava Swami is absolute owner and kabdar and possessor of this property. There should
Yes.
have been a mention in column number 11, at least, my lords, in other rights column, to the
Yes.
effect that he is not empowered to alienate this property. No
Yes.
such mention is there, and no document is placed on record by the plaintiffs to show that the name of Channabasava Swami is entered by virtue of the partition deed, so that
Yes.
I could have searched into that document also. That has not been done, my lords.
Yes. Sir.
Secondly, my lords, even assuming that, my lords, the Channabasava Swami was not having any rights, absolute rights to
Yes.
dispose of this property in my favor, in that event also, my lords, according to the plaintiffs, their own pleadings, my lords, in the year 1974, there arose a dispute between themselves and the Channabasava Swami.
But the finding recorded by both the courts below,
Yes, ma'am.
by looking into the evidence of the PW1,
Please.
that the Channabasava Swami was holding the social property on behalf of the mutt, representing.
Correct, my lords. As a purchaser, my lords, I am putting forth my defense to the effect that I am a bona fide purchaser, and the true owners or the persons having right, title, and interest in
But
this.
in the event, if he's holding the property as looking after the affairs of the mutt, that does not create a right over the Channabasava Swami to sell the property in favor.
Absolutely correct, my lords. Your lordship is correct in this regard. But as a member of public, and when I have been offered to sell this property by Channabasava Swami,
Yes.
what care I could have taken, I have that care I have taken, my lords.
Yes. Yes.
And the lapse on the part of the plaintiffs is here. They say that in the year 74, there arose a dispute.
Yes.
And they have also produced some records, my lords, including the paper publication of the
Correct,
year
correct.
1974. The paper publication is said to have been made in the year 1974, and I have
Yes.
purchased the property in the year 1990, my lords.
1990. Yes.
At least in the year 1974, the plaintiffs came to know that Channabasava Swami is acting against the interest of the mutt.
Yes.
But what steps they have taken, my lords? For a period of 5 years, still I purchased this property. They have kept them. They have not approached the civil court, though there is a notice issued by them as per Exhibit P10, my lords. Correct?
Yes.
P10, my lords, there is a large notice issued by them,
Yes.
stating that my vendor was acting against the interest of the mutt. But however, they have not approached the civil court to prohibit my vendor from acting against the interest of the mutt. This is this way, my lords, they are negligent and they are stopped from claiming any
Yes.
right in the properties in question. My
Yes.
lords, I may be permitted to refer to this judgment of Honorable Apex Court.
Yes. Citation, sir.
My lords, year 2003 Supreme Court.
Yeah. 2003
3.
Supreme Court.
Lords, 578, page number.
578. Yes.
Yes. Lords, especially Honorable Supreme Court in this para 25.
Para 25. Yeah. Please read.
I may be permitted to read.
Please read. Please read.
Though Estoppel is described as a mere rule of evidence, it may have the effect of creating substantive rights as against the person estopped. An estoppel which enables a party as against another party to claim a right of property which in fact he does not possess is described as estoppel by negligence or by conduct or by representation or by holding out ostensible authority.
Yes, sir.
Estoppel then may itself be the foundation of a right as against the person estopped. And indeed, if it were not so, it is difficult to see what protection the principle of estoppel can afford to the person by whom it may be invoked, or what disability it can create in the person against whom it operates in cases affecting rights. Where rights are involved, estoppel may, with equal justification, be described both as a rule of evidence and as a rule of creating or defeating rights. It would be useful to refer in this connection to the case of Deepuru so-and-so reported in the year 1915 Madras 403.
Yes.
An estoppel, though a branch of the law of evidence, is also capable of being viewed as a substantive rule of law insofar as it helps to create or defeat rights which would not exist and be taken away but for that doctrine. Of course, an estoppel cannot have the effect of conferring upon a person a legal status expressly denied to him by statute. But where such is not a case, right may be claimed as having come into existence on the basis of estoppel, and it is capable of being enforced or defended as against the person precluded from denying it. Thus,
Yes.
my lords, here the plaintiffs are negligent. According to their own pleadings, my lords, the plaintiffs came to know that the Channabasava Swami was alienating the properties or creating the encumbrances over the properties. And they spend time in revenue proceedings. And in their legal notice, they expressly said that they are going to take a civil and criminal action against the my vendor, Channabasava Swami.
Yes.
For a period of 6 years, they have kept mum.
Yes.
For a period of 6 years, till I purchased the property.
Yes.
So, my lord, this conduct on the part of the plaintiffs go to
Yes.
show that their negligence, their gross negligence
Yes.
has allowed Mr. Channabasava Swami, my vendor, to enter into such a dealing. Though
Yes.
I am not directly concerned with it, but he being my vendor, my lords, he has acted, according to the plaintiffs, he has acted against the interest of the mutt. This is number one. Thus, my lords, now, after a period of more than 7 years, they filed the suit. From the
Yes.
year 1974, my lords, according
Yes.
the real cause of action for them arises in the year 1974.
Yes.
And they filed the suit in the year 1993. My lords.
Yes.
For a period of 9 years, they have kept mum. In the interregnum period, my lords, in the year 1990, the sale deed is executed in my favor.
Yes.
But however, to take an action against my vendor, the cause of action, real cause of action arose in the year 1974 itself.
Yes.
Lords, though they have filed the suit in the year 1993, they have not sought for any relief as regards the sale deed in my favor is concerned.
Yes.
They have only got their prayer amended in the year 1997 by virtue of an amendment.
Yes.
Amendment order dated 21/3/1997.
Yes. Yes.
Have passed. After the sale deed in my favor, after 7 years, they are seeking the declaration that the sale deed is not binding upon them.
Yes.
And the amendment of a prayer should will operate from the date of its amendment, not from the date of the suit, my lords.
Yes.
It is well established principle of law. So
Yes.
that way, my lords, that prayer itself is barred by the law of limitation. That is another substantial question of law.
Yes.
Coming to other aspects, my lords, according to the plaintiffs, my lords,
Yes.
the mutt is a religious institution.
Yes.
They say that it is a family mutt.
Yes.
But another document produced by them itself, my lords, there is a punch thorough as per exhibit P10
Yes.
of the year 22/8/1937.
Yes.
The contents of this punch thorough, this document goes to show that it is a My lords, I think I am audible to my lords.
If you look at the substantial question of law,
Yes,
that
ma'am.
is only with regard to the recitals in the partition.
Correct, ma'am. But additional substantial questions of law can be framed at the time of, because my lords, today itself, I have, the law is.
On limitation also, very well.
Yes, ma'am. And if your lordship
But
permits
it's
me,
a 2009 matter, it's a 2009
True,
matter.
I'm definitely I'm aware of the age of the case. That's why I'm ready to argue the matter today itself, ma'am,
Better.
without seeking for any further adjournment. But
But
the
substantial question of law is only with regard to the exhibit P4.
correct, madam. So far, it is already framed by the Honorable Court at
Yes.
the time of admission. But
Yes.
at the time of passing the judgment, definitely the Honorable Court can look into other points regarding substantial questions of law. And if
Yes.
your lordship permits me, I will file.
But the only thing is whether you raise it before the first appellate court.
My lords, the questions of law need not be.
No, unless you, even otherwise. Otherwise, it has.
My lords, regarding limitation is concerned.
So this is under section 100. Unless you raise this point before the first appellate court.
No, my lords,
That's why I've gone through the judgment of the first appellate.
I do concede, my lords, but so far as this bar of limitation is concerned, under section 3 of Limitation Act, though it is not raised as a defense, my lords, of the Honorable Court.
Yes.
Can,
but in the second appeal, it is very difficult to raise.
My lords, it being a pure question of law.
Maybe
No, I will see the law on this point. Definitely, I will see the law. Whatever the Honorable Court has raised this question.
The only thing is, both the courts have relied upon Exhibit P4 and have come to a conclusion based on the recital in the Exhibit P.
Correct, my lords. But
saying that your father is having only a limited estate.
My lords, not my father. The father of defendant number 1.
Defendant number 1. Defendant number.
I'm
Your vendors. Your vendors.
My vendors, my lords. True, my
yes, your vendors.
But my lords, the courts below have not seen from my point of view as a bona fide purchaser.
Yes, sir. But when your vendor himself is having a limited estate, how can the purchaser will get the?
I do agree, my lords. I do agree. But what steps have been taken by the plaintiffs here?
That's a different aspect. But the basis for your case is 1940 document.
Yes, ma'am.
So we have to go by that Exhibit P4.
Correct, my lords.
It confers only the limited estate.
Your lordship may kindly see whether I was having the knowledge of that partition and the rights of the parties.
Caveat emptor.
Correct, my lords. Even then, my lords.
The purchaser must know the antecedents actually.
My lords, whatever is possible for the purchaser, because the things which are not beyond the reach of the purchaser, my lords,
yes.
It cannot be stated that the purchaser was having the knowledge about all those things.
Yes, sir.
And in this regard, my lords, one more edition of our own.
Yes, sir.
Report, my lords, reported in the year 2004, Karnataka.
Year 2004, Karnataka.
Page number 258, my lords.
Page number, sir?
258, my lords.
268, yes.
258,
258, yes.
Sir. In this para 12, especially.
Yes.
May I read this para?
Yeah, please read it.
The plaintiff claims that he is in continuous possession and enjoyment. However, the plaintiff has not produced any convincing evidence by way of record of rights extras to show that his continuous possession and enjoyment as on the date of suit. On the other hand, the evidence of DWs 2 and 3 disclose that the first defendant was in possession and enjoyment of the land after Exhibit D1. Only by the fact that the guardian of the fourth defendant is not examined cannot be a valid reason to raise adverse inference against the defendants to hold that they are not bona fide purchasers. The transactions reflected in the revenue records and the registered documents fully supports the ostensible title and position of the first defendant. DW1, the father of the third defendant, has testified to the fact that the defendants 3 and 4 were guided by the registered documents and the revenue records while purchasing the property under Exhibit P17 and P18.
But your basis is the 1991 sale deed.
1991 study.
Yes,
But
you cannot claim even adverse possession also.
I'm not claiming, even in this case.
Even that case, whatever you are referring to is relating to the possession.
My lord, here also the
Yes.
issue was not regarding adverse possession. Issue was only regarding bona fide purchaser and sale by the ostensible owner here.
Yes, yes. Sir, your good name, please, sir. Just a minute.
I'm Mr. Arun Nilopant, my lord. Arun Nilopant.
Arun Nilopan, yes.
Yes.
But, sir, Nilopan, sir, if you look at the finding recorded by both the courts,
Correct, my lord.
so they look into the recitals in Exhibit P4. In fact, rightly, as a complete conclusion, prima facie, I would say that the Channabasava was holding the Sushre property as a Matadhikari.
Exactly. Forgetting
But
that.
not an absolute, but there is a bar in the partition deed.
True, my lord. I do concede. But
Yes.
at the same time,
Yes.
the courts below shall have to examine that whether I am a bona fide purchaser or not.
Yes.
And whether their reasonings based on the para 6 of my WS is correct or not. And
Yes.
if that is gone, my lord, the courts below ought to have heard that I am a bona fide purchaser.
Yes, sir. Maybe true, sir, but caveat emptor is there.
Correct, my lord. Even then,
Yes.
my humble submission is, as a purchaser, what documents, to what extent I could have probed into. The material documents would be for a period of about 12 years or at the most 30 years. Not beyond that much, not beyond 30 years. And all these days, the name of Channabaswamy, my vendor, is shown as the absolute owner in the record of rights. Though
Yes.
record of rights do not confer any lawful right in the
No,
property.
Nilopan, sir, I do not find any acceptable ground. Sorry.
At least, my lord, your lordship could have examined the case as regards my point of view, that bona fide person. That is one thing.
That's not a case for interference.
My lord, one more thing.
Yes,
Here, if your lordship is pleased, I may permit to urge some more points. If your lordship is pleased to go through the recitals of this 41 cell deed.
Exhibit, yes.
41
Please
partition.
Please read.
Deed of partition.
Yes.
It is as per exhibit P4 months.
Yes, exhibit P4.
Particularly.
Yes.
On 11th page, ma'am.
Yes, please read, sir. Please read. Only thing what you have to point out that whether the Channabaswamy is having an independent right over the property.
That is one thing, ma'am. Second thing is whether the plaintiffs have any locus standi to maintain this suit is also one of the substantial question of law.
Yes.
My lords, here the prayer, if your lordship is pleased to go through the prayer, they say that
declaration that the
plaintiffs are having the right to hold the property. It is not their case that they are individually entitled to these properties. My lords, the question is, the properties are meant for the use of the mud. Now the mud is not in existence. That is a different aspect.
Yes.
But they ought to have sued the defendants on behalf of the mud. That is not been done. On behalf of the mud, it is an institution, my lords.
Yes, sir. Yes.
And an action ought to have been brought on behalf of the mud. Mud is not a party here.
Yes.
That is one thing. Secondly, my lords, according to the plaintiffs, after the turn of Channabaswamy, that is my vendor's turn, their ancestor, one Mr. Shivarudraya. His family should hold the Matadhikari post.
Yes, correct.
Any member of his family. And my lords, in this in page number 12, your lordship may kindly see.
Yes, sir. Please go to relevant paras.
Uh,
Please read. Relevant to,
last four lines.
yes,
In this,
sir.
12th page. ಕದಾಚಿತ್ ಯಾರಾದರೂ ತಮ್ಮ ಪಾಳಿಯಲ್ಲಿ ಅಂದ್ರೆ ಇನ್ ದೇರ್ ಟರ್ನ್ 12 ವರ್ಷಗಳವರೆಗೆ ಪಟ್ಟಾಧಿಕಾರಿಯನ್ನು ಗೊತ್ತು ಮಾಡಿಕೊಳ್ಳದಿದ್ದರೆ ಅವರ ಪಾಳಿಯ ಹಕ್ಕು ನಷ್ಟವಾಗಿ ಅವರ ಮುಂದಿನ ಪಾಳಿ ಶುರು ಮಾಡಿಕೊಳ್ಳಬೇಕು. So, my lords, what happens here? They ought to have appointed a matadikari to act for that post of the mat, and within 12 years.
Yes.
Channabaso Swami, my vendor, died in the year 1991, on 6/6/1991, my lords. It is an admitted fact.
Correct.
From 1991.
6/6/91. 6/6/91.
Yes, my lord. From 1991 till a period of 12 years, they ought to have appointed a matadikari.
Yes.
Who could take over the charge of all these properties. And if on their failure to get an appointment of matadikari.
The only thing is these things have been pleaded.
No, my lords, this is an subsequent event. The 12 years period has lapsed only during the suit, my lords. And I am supported by a decision in this regard.
Yes.
Of Honorable Apex Court. Subsequent events can be.
That's correct, sir. Subsequent event.
Yes, and
but only thing is subsequent event can be whether it has been urged before a trial court is the question to be.
My lords.
Not in section 100.
No, my lords. This honorable court can also.
No.
The section 100 examine the.
No, sir, with
because my lords,
respective, it cannot be urged.
My lords.
The section 100 you cannot.
In this, my lords, decision which I am referring to now, reported in year 1981 Supreme Court, page number 1981 Supreme Court.
Yes, sir.
1113, my lords, page number.
1113? 3, yes, sir. That is related to subsequent event.
Subsequent event. My lords, it was a case for.
1113. Yes.
In this case, my lords, the landlord fought for the eviction of the tenant. And during the litigation, my lords, the landlord ceased to be a landlord. He loses his authority. My lord,
so that's true. That subsequent event you may raise it in the original jurisdiction.
My lords, that would come only in the year 2003 onwards.
But whether it can be pleaded in whether it can be heard in the section 100 proceedings.
Definitely, my lords. According to me, Lord.
No. You cannot take any even new plea. Actually.
No, it cannot be a new plea, my lord. So in view of this subsequent event.
Yes.
All it is subsequent event, my lords.
Yeah, madam. 1113. Yes.
Of particularly para 17, my lords.
Para 17. I will look into it. Yes.
Sorry, my lords. There is some. Para 15, 16, and 17, man. 17.
15, 16, 17. Yes.
More particularly in para number 17.
Very well.
May I read it, man?
Please read.
Once this subsequent event of landlord's interest in the property getting extinguished as the property in question is allotted as an exclusive owner to a sharer upon a partition amongst co-sharers is properly evaluated, unless some proper explanation is offered by the landlords who are parties to a proceeding, the plaintiffs are liable to be non-suited. This does not require much of a discussion because plaintiffs have sought possession for personal requirement of respondent one, Manohar Lal Sharma. Manohar Lal Sharma wanted to start his clinic as he is a qualified medical practitioner in the suit premises. Manohar Lal Sharma is neither an owner nor a co-owner, nor he has any interest in suit property. Since the date of partition effected by compromise, between the co-sharers in the suit of 4/74. If action were to start today or a day after the decree for partition, could Manohar Lal Sharma ever file a suit for evicting the present appellant from the suit shop on the ground that he wanted to start his clinic in the suit shop? If Manohar Lal Sharma can bring such an action, he can as well evict any tenant from the premises with which he has no connection. So this is the inference drawn by the
Yes,
Honorable Apex Court, my lord. So that's why from the year 2003 onwards,
Yes,
they
sir.
have no existing interest in the properties in question as Matadhikari, because, my lords, for the simple reason that there is no appointment of Matadhikari as per the recital of this
Yes, yes,
1940 deed.
yes,
And whatever right that goes to the next generation, that is the family in whom the right of return is vested with. That is
yes.
Gurlingaya's family. So
I
they have
shall
to take,
consider it. I shall consider. Yes.
my lords, even the Trust Act, they say that it is a property belonging to the religious trust, that is mud. Section 64 of the Trust Act also, it's very important, my lords.
That those plea can be raised only by the defendant number one.
No, I having purchased the property, I have stepped
But you
into
are
the shoes.
purchaser of the property.
Yes, ma'am.
Yes.
I have stepped into the shoes of my vendors. So far as
Yes, yes.
taking the defense is concerned,
Yes, sir.
64, my lords.
Yes.
Indian Trust Act, section 64, my lords.
Trust Act. Indian Trust. The only question that these aspects find place in the written statement.
I do consider, my lords, but your
No,
questions of,
Nilapan sir, it cannot be required.
my lords, pure questions of law
No,
can
no,
be
no.
raised even
Even
under
that,
section.
even take for an example, the consideration made by me also only with regard to the substantial question of law which has been already made.
But however, your lordship is aware that
So, no, Nilapan.
additional substantial questions of law can be raised
Not
at the time of.
but there is no pleadings.
My lords,
At least you must have raised these aspects in the before the time
of course, I do consider that there is no pleadings by way of my defense statement. But however, my lords, under section 100, this honorable court has got every power to
Yes.
consider these pure questions of law.
But if you look at the year 1965 SC,
Yes, ma'am.
just plea depending upon further investigation also not allowed for first time in appeal under section 100 of CPC before
No, it is.
year 1965 SC 1752. There also the matter is pertaining to the partition between the parties as such.
Yes, ma'am.
Not a case. I don't find any.
Section 64 also, your lordship.
Yes, I shall consider, but not a case. Not a case. Sorry, sir. Discuss. Reasons to follow dismissed. Yeah, 96. Yes, Patil.
Obliged.
Yes, sir. I do consider. Add more.
Demander. Number 38, Kiran Naik.
Yes. Yes, yeah. That is a different thing. That's no. Just is relative with mixed submissions. Otherwise, you know the result. Because it is already heard. And if you go to the paragraph 21 reveals everything actually. No, remand. Not necessary, not. Otherwise, all the matters we have to send back. Only we have to see the available evidence on record and nothing else. Just have it. No, nothing else.
Because the property was not even constructed when the rent agreement was executed.
Yes, sir.
There's no problem.
We should not have entered into an agreement. If such been the case, we should not. I know. Yes, very good. Only to clear the loans, he rendered his loans.
That has been acknowledged by the son of the respondent.
Just if you require a reasonable period, I can accept that. I can give you 10 minutes. I can talk to him. That's all. No. No. Maximum 2 days I can. Very well. That's also possible. That's possible. Possible. Just 10 minutes. Otherwise, you know the result. Only reasonable period. That's all.
Only one.
He'll No. Only between the parties. Only for the parties. Sir, finding is against you. You should be know the result. No, that is a different thing. That's it. Just I can pass it over for 10 minutes. Yes, Krishna Swami. What is this? So, Yavat. Yavat. Very good. Yavat. Part further in 27, sir. Tuesday. On 28. Batch, we have a batch. After admission, after preliminary. After preliminary. No. 28. After preliminary, it will be taken up further in. Yes. Yes, ma'am. Yes, ma'am. Very nothing else. For both the petition respondent and amicus query, where this court has appointed. Why? Yes, 2014. Yes, how much was granted in 125 proceedings? Where is that? Because this RPFC is arising out of 127. Oh, okay. 800 rupees per month to the petition number 1. This set. To the wife. That is a petition number 1 here. Yes. So 500 for the R2, P2. Yes. Now it has been announced to Yes, that has been cancelled. Yes. Yes. Yes.
That way, if you two lines.
Yes. Trim. Exhibit P by way of memo. Yes. Very, very. Yes. Yes. Now the marriage is dissolved now. By virtue of MC number 215. Yes, yes. Exhibit P7. Yes, where is that one? 26. 26 is the impugned order start. Paragraph here, paragraph. When the parties have entered into agreement with its own so. Internal page number 7. Yes. Yes. Contrary. We will allow it and we allow it. Confirm. Third. Since let us know. It should be contract. I think section 23 of contract. I know. Husband. This petition Since 2014, it is pending. With judgment. So and so is another. I think in para 18, no settlement of claims which does not officials. 18, go to 18. Maybe we shall. Yes. Huh? No. It's 2014. You argue. If you want to argue, you can argue. No. Maybe inconvenience for everyone. It's a date given matter. On the last occasion also, I think. Even otherwise, the contractor is that cannot be waived also. Thirdly, this revision petition is filed. Please sit down, please. This petition is filed by the respondents in CMIS number 103 of 2013, on the file of the Family Court, Davanagere, challenging the order dated 27th October 2014. Allowing the petition by cancelling the order dated 13/7/2007 in CMIS number 18 of 2006 by the family court. The relevant facts for so and so family court. Please sit down. It is the case of the petitioners in CMIS number 18 of 2006 that the marriage between the petitioner and the respondent therein was solemnized on 7/4/2002 at Katalagere village, Chennagiri Taluk, and in their wedlock, the petition number 2, and in their wedlock, petition number 1, marriage petition number 2 is the wife. Marriage between the petition number 2 and the respondent, and in their wedlock, petition number 1 was born. In view of the family rift, the petitioners have left the matrimonial home and as such residing separately from the respondent husband. Accordingly, the petitioners have filed CMIS number 18 of 2006 seeking maintenance. The said petition was contested by the respondent husband by filing objection. The family court, after considering the material on record by its order dated 13th July 2007, directed the respondent dash husband to pay monthly maintenance of rupees 500 per month to the petition number 1 and rupees 800 per month to the petition number 2. However, rupees 1000 rupees was awarded towards litigation expense. The said application was, the said order was challenged by the respondent husband by filing application under section 127 clause 3 clause B 1 of CRPC, and the said petition was contested by the petitioner wife and her child and their child. He said, full stop, the family court, after considering the material record, cancelled the award of maintenance made in CMS number 18 of 2006 dated 13/7/2007. Feeling agreed by the same, the petitioner wife and the child have presented this revision petition. Amicus curiae. This court by order dated amicus curiae. This court by order at 8/1/2021 appointed Srimati Archana KM as amicus curiae for the petitioners to defend the case of the petitioners. You are also amicus curiae? Yes. When you was appointed? Thereafter, this court by order at 8/2/2021 appointed CH Sandesh as an amicus curiae on behalf of the respondent hearing. I have heard Madam so and so and Madam Sri Sandesh appearing for the respondent. Then a counsel appearing for the petitioner, counsel, Madam so and so. Madam so and so, amicus curiae on behalf of the petition hearing, invited the attention of the court to the finding recorded by the family court and submitted that the reasons assigned by the family court cancelling the award of maintenance made by the family court in CMS number 103 of 2013 is incorrect, which requires to be interfered with in this petition. She further contended that the finding recorded by the family court that in terms of the settlement between the parties, the petitioners herein are not entitled for the maintenance, which is contrary to the public policy in terms of section 23 of the Contract Act. Accordingly sought for interference of this. Per contra, Mr. Sandesh and counsel is also appearing for the amicus curiae for the respondent, sought to justify the impugned order passed by the family. In the light of the submission made by the in the light of the submission made by the Lana Council appearing for the parties, it is not in dispute that the petition number 1 is the wife of the respondent and in their wedlock. Petition number 2 herein is born. On careful consideration of the records would indicate that the marriage between the first petitioner and the respondent was dissolved in MC number 215 of 2012, dated 13th November 2013, within bracket Exhibit P7 on the file of the Family Court, Davanagere. That apart, the claim petition made by the wife and child in CMS number 18 of 2006, whereby the Family Court awarded maintenance, and the same was interfered with by the Family Court in CMS number 103 of 2013 on the ground that there is a settlement between the parties. Having taken note of the finding recorded by the Family Court, particularly with regard to the fact that the parties have settled the matter by way of agreement, and on the other hand, at paragraph 11 of the impugned order, has taken as pointed out that there is no specific reference in Exhibit P2 and P3 that the said documents are executed in full and final settlement of the parties. It is well established principle in law that any such agreement with regard to the claim made by the parties under section 125 or 127 should be within the parameters of the scope and ambit of the said provisions. And the finding recorded by the Family Court in CMS number 103 of 2013, that the wife, the petitioner petition number 1 wife has waived off the maintenance, despite the petition number 1 has stated that no such agreement has been entered into between the parties. That way of the matter, the finding recorded by the Family Court in CMS number 103 of 2013, dated 27/10/2014, is contrary to the law declared by the Apex Court in 2015, year 2015 is so and so, Imam Faruqi, so and so. And it is well established principle in law that payment of maintenance by the husband to the wife is a social measure under Article 15, Clause 3 of the Constitution of India, as a Constitution of India. And in such circumstances, since Article 15 of the Constitution comes under the purview of Part 3 of the Indian Constitution, in view of the law declared by the Apex Court in the case of Bashishar Nath versus so and so, CH-23. No, it is held that the fundamental rights cannot be waived off. And in that way of the matter, it is the duty of the state and as well as the citizens to safeguard the so-called fundamental rights enumerated under Part 3 of the Indian Constitution. In that way of the matter, the revision petition is allowed and order dated so and so in CMS so and so is set aside. Yes. It's also placed on record the assistance rendered by both the Lanark Council, who have been appointed as amicus curiae in this matter, and their assistance is and their assistance is placed on record. Yes. Next. Yes. 38. Yes, sir. Any reasonable period that I can accommodate that, sir, except that nothing else. 6 months is reasonable. No. Whatever. No, nothing else. 6 months you can grant. This is a reasonable period. How much it comes around? Be considerate. File a memo. No 3 months. Otherwise, I will, for every submission, 3 months enhancement. That's all. See, 6 months is okay. It's permissible. 6 months is permissible. Normally, it's a reasonable period. Anyway, he has constructed. So you have to balance the very same, both the parties. When you are going to file affidavit, 6 months and wait off the rent. Now, next 6 months he will pay. Next 6 months you pay. Now, next 6 months, what is the rent has been that you are paying? You pay 6 months. Insofar as till the order of this court, till the court, whatever the arrears you waived it. Where is deposit? It will be returned to you. It will be returned to the respondent. Anyway, is waiving 3 lakhs. Both of you can file an affidavit when. Not even. 6 months is a very reasonable thing. Think normally there are 2 years, likewise 1 year like this. 6 months is a very reasonable period. Tell me. Then a council appearing for full stop. Then a council appearing for the party submitted that there is a likelihood of settlement between the parties and seeks time to file the settlement report by day after tomorrow. 2:30 get corona. That they will also be present. Friday, do one thing at 1:25. 2:30 in the event if I may go to division bench. 1:25. List at 1:25. Reporting settlement. Very good. 6 months is very good. Reasonable. One para ಇವತ್ತು ಒಟ್ಟೊಟ್ಟಿಗೆ ನಾನು ನೋಡೇ ಇಲ್ಲ. 2 paras ಡಿಕ್ಟೇಟ್ ಮಾಡಿ. ಅದು ಗೊತ್ತಿಲ್ಲ, ನಾನು ಬರ್ಕೊಂಡು ಇದು ಮಾಡ್ತಿದ್ದೆ. ಐ ಥಿಂಕ್ ಒಂದು ಲಾಂಗ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಕೃಷ್ಣ ಮತ್ತೆ ಲಾಂಗ್ ಜಡ್ಜ್ಮೆಂಟ್. ಕಂಪ್ಯೂಟರ್ ಆಫ್ ಆಗ್ಬಿಟ್ಟಿದೆ, ನಾನು ನೋಡೇ ಇಲ್ಲ. ಕಂಪ್ಯೂಟರ್ ಆಫ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ, ನಾನು ನೋಡಿಲ್ಲ. ನಾನು ಹೇಳ್ಕೊಂಡು ಹೋಗೋದು ಲಾಂಗ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಾನು ರೆಕ್ಟಿಫೈ ವೆರಿ.
ಆಯ್ತಲ್ಲ.